Hello and welcome to today's session on an introduction to procurement law. We will start with the introductions to the speakers today. My name is Radhika Devasher and I'm an associate at Sharp Pritchard. I work in the projects and outsourcing team and I mainly work with local government clients. Over to my colleague Hannah.
Hi, I'm Hannah Ismail. I'm a solicitor in the projects and outsourcing team, and I also mainly work with local government clients. I'm going to pass on to my colleague Natasha.
Hi, my name is Natasha. I'm a paralegal in the projects and outsourcing department.
Right, sorry, I apologise for that. I think there's some interference with that, but we'll hopefully deal with that soon. If we can switch over to the slides now. So as you can see, we have an ambitious presentation to get through. So I thought I'd summarise about the general topics we'll be covering. So those topics are: why do we need a procurement regime? When does it apply and not apply? We will look at the procurement procedures available, and then talk about the light touch regime. After that, we will look at frameworks, evaluation and award. We will also look at the area that causes a lot of problems, contract changes, and finally we'll take just a brief look at Brexit and the implications following the transition period. In terms of questions, please do include questions in the chat box facility, and we will try to answer queries as they go, but if not, we will deal with them at the end of the session. And again, if we run out of time, we will send an email following the session addressing all queries. Right, so to start us off, why do we need a procurement regime? So the main idea is that it is an agreed way in which the public sector seeks to procure its goods, services and works. So currently, as part of the EU member states, we agreed to procure on the basis of the treaty principles, equality, transparency, proportionality and non-discrimination. We'll touch upon those in a bit more detail later, but you'll be pleased to know these principles will continue to apply even when we leave the EU shortly. In addition, the procurement regime helps to prevent fraud, corruption, including bribery and nepotism, which unfortunately used to be common practice when awarding public sector contracts. And finally, again, not so relevant shortly, but it did help to prevent national bias and make sure competition was opened across the whole of the EU, which helped to support free movement of goods and services. Again, won't become that relevant following our exit of the EU. So when do we need to think about the public contract regulations? So they are applicable when a contracting authority needs to enter into a contract for the provision of services, goods or works. A contracting authority includes all central government departments and local authorities, and it's more particularly defined in the procurement regs if there's still uncertainty as to whether your authority is covered by them. Not only does it apply to new contracts, but also varying existing contracts, specifically those to be stated above the EU thresholds. And we'll touch upon those later. Just a note on property transactions as well, that they are exempt. However, procurement issues may apply where the procurement sale comes with additional obligations imposed by the council. That's not specifically covered in this talk, but if you do have any queries on that, please do include them. We might be able to touch upon them in this talk, or we can deal with them after the session has ended. So what can go wrong when we don't follow the procurement regime? So as the first point says on the slide, the authority could receive a procurement challenge. And we all know that that's what contracting authorities try to avoid at all costs. The second stage is if the challenge is successful, there are three main things that can occur. The first is the decision to award the contract might be overturned, and this would require the re-procurement of the contract, or the losing bidder may win the contract instead, which obviously is very messy. The second thing that could happen, which again is not great, is that the authority could end up paying twice for the contract. And this is where the contract remains with the winning contractor as they were awarded. However, the challenging bidder who's lost may be rewarded damages for the loss of profits, which duplicates the contract price. So yeah, again, not a great situation to be in. And finally, there may be a declaration of ineffectiveness, whereby the contract is held to be void. There may be a civil penalty, and the contract will need to be re-procured. As you can see, there's a note on the slide as well that highlights that where the challenge has been successful, not only has the authority got to pay its own legal costs, but also the challenging party's legal costs. And on top of that, there's huge delays as to when, to the intended contract award date. So as you can see, I think that slide really represents why we really should follow the procurement regime when appropriate. So over to my colleague, Natasha now.
So the legal framework for procurement law in the UK is based on the EU directive that came into force on the 18th of April 2014. This was transposed into UK legislation on the 26th of February 2015 as the Public Contracts Regulations 2015. This governs how works, supplies and services are procured by contracting authorities. Note that there are separate regulations that cover both utilities contracts and concession contracts, but this isn't something that we're going to be discussing in today's presentation. Another key piece of legislation is the Treaty on the Functioning of the European Union, the TFEU. This outlines the overarching procurement principles that should be borne in mind when procuring goods. These are equality, transparency, non-discrimination, proportionality, and mutual recognition. And these principles are enshrined in the PCR at Regulations 18, which governs general principles of procurement, and 4210, which governs formulating the technical specification. You will have seen recently that procurement has been hitting the headlines a lot in the wake of the outbreak of COVID-19, and there's been particular scrutiny around the procurement of PPE, which is allowed under the emergency procedures in the PCR. But this really just highlights how important these key principles are. So first we'll look at when the procurement regime doesn't apply. There are a number of scenarios in which the procurement regime won't apply, which are outlined in section 1 of the PCR. These include expressly excluded contracts. We aren't going to go into these in a lot of detail, but the types of contracts that are excluded are stated in the regulations 7 to 12, and these include utilities, electronic communications, and arbitration services. Also, where the estimated value of the contract is below the relevant financial threshold. We'll be looking at the thresholds later in this presentation, but these are instituted by Regulation 5, and the thresholds are updated annually, so that's something to keep an eye on. Additionally, if the purchasing body is not a contracting authority, the procurement regime will not apply. There's a light touch regime for social and other specific services, which allow for a relaxation of the rules, but the PCR will still apply. So now we'll look at when the procurement regime does apply. It will apply when a contracting authority seeks offers for goods, services and/or works as a contract, where the estimated value of the contract or framework agreement in question is at or above the relevant financial threshold. So you should be able to see the financial thresholds up on the screen now. Note that the supplies and services threshold is different for central government and for other contracting authorities. So if the contract value is below the relevant threshold, only a small portion of the PCRs are applicable. The main consequence of this is that the contracting authority is not obliged to hold a procurement competition before awarding a contract below the threshold. However, contracting authorities do still have to apply with the TFEU principles that we mentioned earlier, and the only way to ensure compliance is by undertaking some form of competitive exercise. The contracting authority own CSOs, contracting standing orders, will set out the internal competition requirements and the requirements for below threshold contracts. If the contracting authority wants to make a direct award, it will often need to obtain a waiver of the competition requirements under its own CSOs.
Hi, it's Hannah. I'm now going to talk through the procurement process. And as you can see, these are the stages that fall under the whole overall procurement process. The first stage is the pre-procurement planning. This involves preparation of the procurement and business case. So the business case will include briefly what the requirements that you're after within that specific service or works or supply contract, and it will include the procurement procedure that you wish to adopt and some other general stuff like social value. And then it also involves you preparing the contract specification, the invitation to tender, and the contract terms and conditions. You may also wish to undertake a market consultation. This is particularly useful where you have a complex or novel procurement, as the whole process of gathering information from suppliers will help inform your specification, and it will ensure that the specification is workable and tailored to that specific market. Then you have the selection or pre-qualification stage. So this applies where the contracting authority uses a two-stage procurement procedure, which I'll move on to discuss later on. But it essentially is a document which allows the contracting authority to gather basic information about bidders, but also information about their suitability from both a financial and technical perspective. There is a standard template that contracting authorities use, and this is prepared by the Cabinet and Crown Commercial Service. So then you have your invitation to tender stage. This is where you obviously go live with your procurement, and then you have the evaluation stage, award stage, and standstill and post-award stage, which we'll move on to discuss in more detail later in the presentation. So to turn to procurement procedures, there are 5 types under the procurement regulations. You've got the open procedure, restricted procedure, competitive procedure with negotiation, competitive dialogue, and the innovation partnership. Now, the innovation partnership is rarely used. It's used where there is an innovative product or service that the contracting authority is seeking to purchase, and there isn't a solution that's readily available on the market. So we're not going to discuss that in detail today. We're going to address each one in turn, but in summary, the open procedure is used where the requirements is straightforward. The restricted procedure is used where you wish to pre-qualify suppliers. So this is where you would have your selection questionnaire as the first stage, and then you move on to tenders. Negotiated procedures. So there are 2 types. You've got competitive procedure with negotiation and competitive dialogue procedure, which we'll discuss in detail in a moment. So with the open procedure, this is where all interested parties can submit a tender. You're not allowed to pre-select or shortlist bidders. It's just a matter of them submitting their response to the ITT immediately, and no negotiations with tenderers is permitted. The restricted procedure, as I said earlier, is where you want to pre-qualify suppliers through the selection questionnaire. So all interested parties can submit a selection questionnaire, but then only those that are shortlisted will then be invited to submit a tender response. Again, with this procedure, no negotiation is permitted, and it's important to say that there are no restrictions as to when you can use this procedure. Now, with the negotiated procedures, as I said, there are two types, and these are used where the contracting authority stipulates at the outset and knows that there is an element of negotiation that's required. Now, you might want to use them in the following circumstances. So where the first circumstance is where there's no readily available out-of-the-box solution, or there's a need for design or innovative solutions, where prior negotiation is required due to some form of legal, financial complexity, or where there are risks attached with this specific service or supply or works, or where the contracting authority cannot establish the technical specification with sufficient provision. As I said, there are two types. You've got the competitive procedure with negotiation, so the CPN, and the competitive dialogue procedure, the CDP. With the CPN, this is where minimum requirements can be specified at the start, but negotiations with bidders are, is needed to improve the contents of the tenders. The purpose of the negotiation is to improve the content of the offers in order to better correspond with the award criteria and the minimum requirements. So you can't negotiate the minimum requirements and the award criteria. Those are fixed from the start, but it's used as a process to perfect it, to perfect the actual requirements themselves. So tenders can be clarified, specified, or optimized to a limited extent. It's important to say that you can award, though, on the basis of the initial tender submissions without having to go through the whole negotiation process if you feel that the submissions are adequate from the start, but you must specify that you reserve the right to do so within the procurement documents at the start. With the competitive dialogue procedure, so this is used for complex procurements where multiple solutions must be discussed so that you can finalise or start the tender process. So solutions are worked up during your dialogue with bidders, and final tenders can be clarified, specified and optimised. This process does take a long time. It can take a long time, especially where complex contracts are involved. Now, to turn to the light touch regime, which my colleague Natasha touched upon briefly, this applies to Schedule 3 services, so known as social or other specific services, and can include the following sectors: the health and social and related services, so this includes domestic help, nursing or medical personnel. You've got it also applies to administrative, social, educational, healthcare and cultural services, benefit services, and other community, social and personal services. The basis of the regime is to provide the contracting authority with a great deal of flexibility with the procurement process that can be adopted. The only requirement is that the contracting authority publishes a notice at the start of the procurement process and at the end, but there is flexibility with what a procedure that you adopt. Most contracting authorities opt for the open or restricted, just because they're fairly easy to use, but you don't actually have to adhere to the stipulated time limits under those two procedures. The only requirement is that you ensure that you allow proportionate and reasonable time limits for bidders to submit a response. So practical tips. So these are the following questions to ask yourself when considering the right procurement procedure. So the first point is, what is the nature and scope of the proposed work, supplies or services? Does the light touch regime apply if there is a social element involved? I think if you've also got existing contract in place, it's useful to look at what the current arrangements are. and then build from there. Timescales, is there a particular is there a specific urgency attached, and what are those reasons? And can you estimate the number of interested bidders from the start? So this is where your pre-market engagement would come in handy. Also consider the likely estimated value of the contract. Consider whether there's a suitable framework that can be used. My colleague Radhika will move on to talk about frameworks in more detail. And also consider if you're doing this procurement jointly with other contracting authorities. I'm going to turn to hand over to Radhika, who's going to discuss frameworks.
Thank you, Hannah. Right, on to frameworks now. This is an important area to be aware of because they are heavily relied upon by many contracting authorities to really just save time and costs of having to run the procurement yourself. So in short, a framework agreement is an umbrella agreement which sets out the rules upon which the parties to the framework will enter into call-off contracts. So they are set up for goods, services and works, and they'll be more specifically described within the framework itself as to what goods, services or works they apply to. A framework can be set up with more than one provider who will deliver the goods, works or services to the contracting authority who has called off from it. And in the same way, the framework can be set up to allow for more than one contracting authority to be permitted to call off from the framework. So in eventualities, you can have more than one provider providing to more than one contractor under a framework agreement. To add to that, frameworks can be divided into lots. So this in effect categorises the goods, works or services into specific groups. And on the next slide, we'll talk a little bit more about lots. So they can apply to procurements for contracts and frameworks. And I think the best way to really illustrate how lots work is through examples. So if we look at the first example on the slide, so that's computer hardware. So by using the division of lot 1 specific to laptops and lot 2 specific to desktops, it allows for providers to submit bids for the lots that they intend to be a supplier for. They might not have the capacity to deal with both lots, so that they can only bid if laptops is what they can bid for, supply, they will only bid for lot 1. Alternatively, you might have quite a large supplier who can do both lots 1 and 2, and if the framework rules allow, they may submit bids for lot 1 and lot 2. So moving on to facilities management is the next example. Here it's been divided in lot 1 soft FM and lot 1 hard FM. So the same thing applies. If a bidder can apply for both lots and it's permitted by the framework rules, by the invitation to tenderers, then they can submit a bid for both. However, in some cases, councils like to keep them separate and divide up their contractors. So it might be a rule stated in the instruction to tenderers that you can only bid for one lot. Right, now looking at another example that I thought would be quite apt to mention is the fact that EM Law Share itself is a framework. And here is an example of a framework on a larger scale where we have a number of providers under each category. And really it just allows contracting authorities to go straight to the category or the lot that they wish to call off from and have a look who could provide the service under that specific lot. So looking at practical tips now, so starting with frameworks. So they're so widely used, it's really recommended that you bear in mind these general rules. So the first one being a framework term must generally not exceed 4 years. There are exceptions to this where the industry may require a longer term, for example, to recoup the investment that was made at the outset of the contract. However, please be aware that when exceeding the 4 years, it always needs to be justified. So the rule of thumb is 4 years, or else it needs to be justified why it's longer. Next, about substantial changes, they are not permitted to be made to call off contracts. Otherwise, the call off contract itself might be subject to a challenge, which we obviously want to avoid. Again, another thing that should be checked is that the contracting authority itself is entitled to benefit from that framework, and they must, if they are, they'd be identified at the contract advert stage. So this again is an important point to note, because if you've called off from a framework whereby you were not permitted or you weren't listed as a contracting authority that could benefit from the framework, that contract can be subject to challenge. And finally, just always read the terms and conditions of the framework, and in particular how to call off from it. So the call off rules vary per framework. You could have a direct award and then therefore you follow that process, or you could have a mini competition. In any event, non-compliance with the call-off procedure may leave the call-off contract open to challenge, which again, as I keep on repeating, we want to avoid. Looking at the next slide now on practical tips with lots, it's really advisable to bear in mind that lots are actively promoted by the procurement regulations, and the real reason being is that you're allowing SMEs to compete in the process, as by carving a contract out into lots, a bidder might be able to bid for one lot, whereas they wouldn't have been able to bid for the whole contract. So although contracting authorities are free to decide whether to apply lots to a specific contract, please be aware that if you choose not to carve out your contract into lots, you should give reasons as to why you are not, and that's in accordance with Regulation 46.2. So really, for any procurement exercise that you carry out, always have that consideration. Can it be carved out into lots? And if you're deciding that it's not appropriate, and it should just, as an audit trail, just be kept note of as to why it wasn't appropriate. Finally, where lots are used, please also always make sure that your instructions to tenderers are clear as to how the lots work. And it could be as simple as allowing every bidder to bid for one lot or more, or all of the lots. However, depending on the nature of the contract, you may want to put rules in place whereby they're only allowed to bid for a specific number. Right, so over to my colleague Natasha now to speak about evaluation and award.
So moving on to the next steps in the process, which is evaluation and award of the contract. There are a number of key points to note when you're considering the award and evaluation processes. The first is to make sure that you are planning early on. The evaluation criteria should be considered at an early stage of the project to really ensure that the right result is achieved for you. Second point is that you should test the evaluation process. The planning process could include market consultation or running dummy scores, so the evaluation criteria should be made known to bidders at the first opportunity. And the fourth point is to keep an audit trail. The reasons for awarding scores to bidders should be documented, and the contracting authority must be able to defend the award process. Where there is a two-stage tender process, the contracting authority's first step is to shortlist the bidders against selection criteria, as we've touched on briefly. They then invite the shortlisted bidders to submit tenders which are evaluated against the award criteria. The selection criteria at the first stage aims to establish whether the bidder is able to perform the proposed contract. This often includes a number of pass-fail criteria, including, for example, the bidder's economic standing, as well as written questions about the bidder's past experience, which is then scored by evaluators against a predetermined scoring scale. The award criteria at the second stage then aims to establish how the bidder will carry out the proposed contract. The tender response is evaluated against the award criteria to determine the cheapest or most economically advantageous tender. Under the PCR, a contracting authority must award a contract on the basis of the most economically advantageous tender, called the MEET criteria. This is determined by scoring the bidder's tender responses based on the award criteria set out in the tender documents. This could include price, quality, technical merit, cost effectiveness, delivery date, and aesthetic and functional characteristics of the bidder's solution as examples. The contract could alternatively be awarded on the basis of the lowest price received, but this is only allowed if the lowest price meets the meet criteria. For example, if the quality requirements set out in the specification are mandatory, that would meet the meet criteria. Note that an award based on lowest price is not permitted for competitive dialogue or the CPM procedures. It's ultimately for the contracting authority to decide the split between quality and price. Some contracting authorities will have a standard split that can't be deviated from without specific requirements. This, for example, could be 60% quality and 40% price. The meet approach requires the contracting authority to decide the relative weighting it should attribute to quality and price. The quality and price scores are converted into percentages in accordance with some preset weightings, and these then create a combined score that should identify the successful bidder. Regulation 67 of the PCR provides that the contracting authority must use criteria linked to the subject matter of the contract to determine the most economically advantageous tender. Examples of this are price, quality, technical merit, environmental characteristics, running costs, cost effectiveness, after-sales service, organisation, qualification and experience of staff, but there are of course many other examples that you may find are relevant to your own procurement. With regard to the pricing of the tender, the contracting authority must specify how the price is going to be assessed. All costs that the contracting authority want the tenderers to include must be set out in the pricing element of the evaluation and disclosed in advance. This often takes the form of a pricing table for the tenderers to fill out. And the contracting authority must also disclose the methodology it's going to use to evaluate the pricing within the tender documents. The award criteria are then allocated weightings that are reflective of what is the most important to that particular procurement. The weightings could be exact percentages or a specified range, and each of the main criteria should then be broken down to set out what the contracting authority is looking for in order to ensure that the scoring is consistent. You can see from the example up on screen now that the quality criteria has been split into 3 sub-criteria and the price into 2 sub-criteria. The quality criteria will then generally be broken down into further sub-criteria. The weighting could either be a set percentage, for example here you can see that there's 50, 30 and 20 for quality, or a specified range, which is the other option up on the screen. Once the submission deadline has passed, the contracting authority must evaluate all tenders. As we've already mentioned, the evaluation methodology must be set out in the tender documents in advance. This can include, for example, written tenders, method statements, presentations, interviews, references, and site visits. It's then ultimately up to the contracting authority to decide which of these are the most appropriate for the particular procurement. One issue that can arise during evaluation is abnormally low tenders. Under Regulation 69(1), the contracting authority must require a bidder to explain the price or costs proposed in the tender if the tender appears to be abnormally low. The contracting authority has a right to reject such a tender if the evidence supplied by the tenderer does not satisfactorily explain the low price. A situation like this should be treated carefully, and there are a number of relevant cases in this area. In Agri-Consulting Europe and European Commission, the ECJ stated that the process should be as followed. So the first step is to identify the suspect tenders and then allow the tenderers to demonstrate their genuineness by asking them to provide any appropriate details. You can then assess the merits of these explanations and ultimately take a decision as to whether to admit or reject those tenders. So rather unhelpfully, there's no definition of an abnormally low tender in the regulations, so it does fall to the contracting authority to determine this. It's really important to ensure that whatever method you do use is objective and non-discriminatory. For example, you could compare the tender to the estimated contract value or to other tenders that have been submitted. So, as we've already mentioned, procurement challenges can occur, and this is often when an unsuccessful bidder challenges an award decision. This means that contracting authorities should take particular care to ensure that the evaluation and award process are both equal and transparent. In particular, we've written some suggestions on the screen about what the contracting authorities could do. So really take the time to read each tenderer's response carefully and make sure that you understand each criteria that's in the scoring table. Also ensure that the evaluation panel gives adequate reasons for the scores given and links each score back to the evaluation criteria. It is much easier to do this as you go along, as this will ultimately form the basis of the feedback that you give to each tenderer. So if each evaluator writes down as detailed notes as possible while scoring the responses, and then the panel will come together to moderate the scores and all of these notes can be collated. It can also help to take a step back and ask yourself, would you be happy to stand up in court to justify the reasons you've given? So we're now going to turn to standstill and contract completion, and I'll hand back over to Hannah.
So, this is the final part of the procurement process overview that you saw earlier, and this is the post-award stage. So, in order to ensure that suppliers are able to seek an effective remedy if they feel that the contracting authority did not comply with the rules, a formal pre-contract debrief and a standstill period must be complied with. So this involves the requirement for the contracting authority to notify all tenderers in writing of its decision on contract award, and it also requires a standstill period of a minimum of 10 calendar days to be applied between the date the notification is sent to all bidders and the date of entry of the contract. I'm going to discuss contract renewal, extension and modifications. So when it comes to a proposed extension, renewal or amendment of an existing contract, the first thing to consider is, does it constitute a material change? The best way to consider whether there's a material change is to ask yourself, is it so substantial that a new contract would need to be in place? Examples would be where you're introducing conditions which, had they been part of the initial award procedure, would have resulted in the admission of other tenderers. Does it extend the scope of the services not initially covered under the original contract? And does it change the economic balance in favour of the contractor in a manner that wasn't provided for initially in the original contract? If there is a material change, then we'd advise that you undertake a new competitive tender process. However, you could consider whether it does fall under 6 specific situations that the regulations, so Regulation 72 of the Procurement Contracts Regulations has allowed for. There are 6 circumstances which are known as Safe Harbours, and I'm going to talk through them in a moment. The first one is that there is a review clause in the procurement documents, so the contract terms and conditions in particular. This is common for contract extensions. So usually the contracting authorities will advertise or stipulate in the procurement documents its discretion to exercise a specific extension period following the expiry of the initial term. The other circumstance is the material change, has it been brought about by a specific economic and technical reason? So can only one supplier carry out those works or services or supplies needed? And has it been brought about by unforeseen changes? So COVID is an example of this. But with this, you do need to ensure that it doesn't change the overall nature of the original contract, and that the value of the additional services don't exceed 50% of the price under the original contract. Has it been brought about by a new contractor? So this is where there's been a takeover, a merger, or some restructuring. Is it an insubstantial modification? So irrespective of value, there are certain circumstances, and it could be regarded as insubstantial if the second bidder, if it wouldn't have changed the position, and if a second bidder would not have won. Is it a minor modification? So this it would be classed as a minor modification if the value of the change falls below the EU threshold, which Natasha put up earlier, and if it falls within 10% of the price if it's services and supplies, or 15% if it's a works contract. So practical tips when it comes to renewals, extensions and modifications. So ask yourself, consider the significance of the proposed change in terms of monetary value and the nature and extent of the services, supplies or works as compared to the original tendered contract. The greater the change in scope, the more likely it is to be regarded as a material change. Also consider whether you're going to be placing the contractor in a better financial position, because that's where it will become problematic. I'm now going, it wouldn't be a complete presentation without a Brexit update, so I'm going to turn to Radhika, who's going to talk through it briefly.
Thank you, Hannah. So you'll be pleased to know that this is the last slide. As I'm aware, we've covered a lot of ground in this session. As you may have heard, the UK's exit date from the EU was on the 31st of January 2020, which I'm sure you will agree seems like an age away now. So we're now in the transition period, whereby the application of the procurement regs have remained the same. Some good news is that following the expiry of the transition period on the 1st of January 2021, only minor amendments will be applied to the current procurement regime. So the most significant change is that instead of using all the OG forms to advertise and declare information about a procurement process, contracting authorities will be required to use the Find a Tender service, the FTS, instead. And this will include uploading the FTS contract notice at the outset of the procurement and uploading the FTS award notice upon conclusion. So is there anything we could be doing now for local authorities, as local authorities? And that is really to look at our contract documents and our tender documents and contract standing orders to update them to reflect the OG's replacement with the FTS. So that's really all that can be done at this stage. Whether there'll be any changes to the regs, obviously your guess is as good as mine at the moment, but at present we're pretty much the same. Right, so I believe so that's the end of the session now, and we'll be able to look at any questions that you have. If you've got any questions that you thought of throughout the presentation, then please put them in the question and answer. Right, so there's no new queries. I notice the time's pushing on. I'll still keep an eye out if anyone does want a last minute question to be answered. But other than that, all I'd say is if you do have any queries to anything that we've covered today, please email us and we can get in touch. But yes, other than that, thank you for joining us, and take care. Goodbye.